From the Toronto Star, I'm Saba Eitizaz, and this matters. There are a lot of questions around the newly legislated Bill 184, with many tenants calling it the Eviction Bill. Are we looking at mass evictions in the middle of a pandemic as soon as next week when the moratorium on evictions is lifted? I had a chat with our reporter Victoria Gibson about that. Hi, Victoria. How are you?
Not too bad. It's a very busy week, but it's been going pretty well so far.
Yeah, I was just going to say it's a busy time covering the affordable housing beat right now in the midst of a pandemic, isn't it?
It has been. And, I've been on this beat now a couple of weeks. And this week in particular is a busy one because the provincial moratorium on evictions is due to lift this month. So there are a lot of questions swirling around on what that means for both rent and landlords, and new legislation from the province is keeping things busy for sure.
And you recently covered a piece about this as well, about big numbers when it comes to pending applications at the LTP, right?
That's right. So this past weekend, we reported on some new numbers from Tribunals Ontario around applications to evict tenants for not paying their rent. And that was between March 17th and July 19th. So right in sort of the heat of the pandemic. And there were 683 applications to evict tenants for not paying their rent in this period that had been processed, which that number in itself isn't out of the ordinary per se, but where some people have raised concerns about it is that the Premier promised in late March that nobody would be kicked out of their houses based on not being able to pay rent during this period, and his government wouldn't allow it to happen. And while filing those applications doesn't guarantee an eviction order, and we don't have details about what the circumstances of those cases were, the broader concern that I've heard is those applications represent efforts to evict more than 6,000 tenants for not paying rent during the COVID crisis.
Did you say 6,000?
6,083 to be specific.
Those are startling numbers a little bit. And now with the development in terms of Bill 184, it seems that a lot of people are worried about that.
So Bill 184 became law just last week, actually. And it's one of the changes in particular that I've heard causing concern. One of the portions of the law allows landlords to apply for eviction orders without a hearing if their tenant has agreed to a repayment plan for rent they've missed, but at some point they don't meet the terms of that agreement. And those changes are going to be retroactive to the start of the state of emergency in March, which has caused some concern that renters are going to end up agreeing to repayment schedules through alternate dispute resolution without fully understanding what their rights are, feeling pressured to agree to plans that they can't afford, and then not being able to have a hearing in their case if they fall behind. And we've seen the likes of even Mary come out and say that no evictions should ever take place without a hearing. Their opinions do differ on the bill. I spoke a few weeks ago to the president of the Federation of Rental Housing Providers of Ontario. He felt it was reasonable to have these kinds of dispute resolution channels. And, the province has said that tenants can also file motions and set the eviction orders aside. But that was also criticized by a lawyer who attended the committee hearings as the bill was working its way through Queen's Park as sort of a backwards process.
And have you talked to any renters who are worried about this or who have any opinions about this?
I have, and to say broadly what people think, because like any political decision, there are sort of a variety of opinions, ranging from, the government shouldn't protect people who haven't paid their rent for months, who might have the capacity to do so, to opinions that the bill will just fast-track evictions and will cause a mass or a surge of them that will lead to more homelessness at a particularly vulnerable time. And during the committee hearings, I was following them a little bit, and there was a lot of concern brought to the government's attention at the time, including from sort of lawyers and tenant groups that thought that it'll disproportionately impact vulnerable renters. There have been protests that have come out on the lawns of Queen's Park, and even though it's a provincial bill, we've actually seen protests outside of the building where John Tory lives, with protesters saying that, Toronto's high rents and this city having to deal with the repercussions means that they should take some sort of action.
As if we didn't have enough things to worry about during this pandemic, right?
It's an interesting conversation because some have suggested that the mayor could actually enact his own eviction moratorium once the provincial suspension ends. But Tory has come back and said that the city's legal team has advised him that they don't actually have that authority. And councillors received a confidential report from the city's solicitor this week, advising them on the possibility of launching a legal challenge of portions of the bill. So that's something that's an ongoing situation that we're going to be keeping an eye on.
Thanks for that insight, Victoria.
Anytime.
That was the Star's affordable housing reporter, Victoria Gibson. To find out what this new legislation actually is and what it will change for tenants and landlords, and to discuss how that impacts the situation of thousands in the middle of COVID-19, let's go to Caryma Sa'd for a legal take. She's a prominent landlord-tenant lawyer, and she's expressing some concerns. Hi, Caryma. Thanks for being on the podcast. It's great to have you on again.
Thank you for having me.
So first of all, can you walk us through Bill 184? What exactly are the provisions that we need to know about in terms of what has changed?
There are a couple of changes that Bill 184 makes to the Residential Tenancies Act in Ontario. I think the one that is probably top of mind for most tenants are some procedural and substantive changes that enable landlords and tenants to sign enforceable payment plans outside of court. And what that means is before getting to a hearing at the Landlord and Tenant Board, parties are able to draft a repayment plan and sign on to that. And should a tenant fail to abide by those conditions, the landlord can request an eviction without a hearing. And that is a significant change because previously, the first step would be attendance at the Landlord-Tenant Board and either a dispute resolution process that's overseen by a trained mediator or a decision made by an adjudicator. And now that is removed from sort of the equation unless a tenant has the wherewithal to challenge an eviction order if a landlord does receive one.
Right. There's been a lot of debate about this legislation. Can we go back a little bit and talk about the background of this bill in the context of existing tenancy laws in Ontario?
Tenancy law in Ontario is fairly robust, actually, and it's really premised on the principle that tenants should have security of tenure. They should be safe from eviction, except for extenuating circumstances. And sometimes those circumstances are what we call a fault basis, meaning the tenant has done something to potentially warrant eviction. Other times, there may be nothing the tenant's done wrong, but the landlord's circumstances require an eviction. And in any event, there's a process to follow, and that process usually involves an opportunity to say your piece in front of an adjudicator at the Landlord and Tenant Board.
And I want to talk a little bit about how this could affect tenants and what they might need to know. But let's look at a real life example. So let's say a tenant needs a broken radiator fixed and the landlord is generally responsible for that and they refuse and the tenant withholds rent. What happens next in this scenario under this new legislation?
So under the new legislation, if the tenant is withholding rent and the landlord moves for an eviction application, assuming that they haven't signed any sort of repayment plan, the landlord would be able to bring the tenant to the board. And Bill 184 makes it so that the tenant is actually required to give advance notice if they intend to raise complaints about the radiator, for example, or other things that might justify reducing the amount of rent that is owed. And that's in contrast to prior, kind of before Bill 184, a tenant would be able to raise those issues right there at the hearing without advance notice. And for the majority of people who are actually quite unfamiliar with the mechanism of the Landlord-Tenant Board, the first time they may learn of this opportunity could be the day of their hearing. So by requiring advance notice, I think what we will see is tenants who have potentially valid arguments to make about why they should be relieved of some of their rent obligations, either unable or in a position where it's difficult to advance those claims.
What do you make of the message from tenants and advocates that Bill 184 will in fact make them more vulnerable to evictions and housing insecurities, while on the other hand, the government is saying this is sort of an attempt to fix the delays and backlogs at the Landlord and Tenant Board? Which is the case here? How do you weigh this?
Both things can be true at the same time, right? And I do think that Bill 184 will expedite processes. However, in my view, it's going to happen mostly at the expense of tenants. And the reason I say that is by all available data, The majority of cases dealt with at the Landlord and Tenant Board are evictions and are landlords attempting to remove their tenants. So when we talk about expediting processes, that is what we are expediting. We're not fast forwarding sort of the ability of tenants to have their issues resolved. There's nothing in the bill that really speaks to that. So I think the concerns raised by advocacy groups are in fact quite valid, and especially given the context of COVID-19 and some of the messaging that was received from Premier Ford himself. On one occasion, he says, if you're choosing between rent and food, buy food. And then he encourages people to make deals with their landlord. And now, with a bill that makes those deals potentially enforceable, and let's not forget that there are renters who are facing various types of barriers, right? Could be language, could be disability. The list is seemingly infinite. These are people who are in an imbalanced situation with their landlord and may have felt compelled to sign something. And Bill 184 retroactively changes the law, meaning if these agreements were signed during COVID, they are potentially enforceable. And that's, I think, a scary thought for a lot of people. And if I can just add, the messaging from the government about sort of strengthening tenant protections, there are some things in the bill that, on its face would appear to benefit tenants. But what the bill does not do is address the fundamental problem in Ontario's housing market, which is that landlords have an incentive to try and remove long-standing tenants. And that's because of rent control and vacancy decontrol. So without sort of fixing or paying any heed to that essential imbalance and that motivation that would prompt a landlord to try and remove longer tenants, and the fact that those tenants then would be thrust into a rental housing market where the going rate is maybe double, triple what they've been paying, I think that we will see people pushed farther and farther and farther from their communities.
As you mentioned, the legislation does talk about some benefit to tenants, right? Like the fact that a landlord would have to give compensation or an alternative living situation if they terminate a lease to move in themselves, for example. Would this not be a way to actually discourage bad faith evictions?
So potentially, but I would say more, I have some reservations about how effective that would be. And I say that for a couple of reasons. It's already the case that if a landlord or their family member is moving in, then compensation is paid. Now, Bill 184 establishes that requirement where a property is being sold and the purchaser is moving in. And it also extends compensation to renovations and repairs where there are fewer than 5 units, because it used to be you could only claim compensation if you're in sort of a larger building or complex. So those are a couple of changes, and penalties for bad faith evictions have also gone up. But what hasn't changed is sort of the law that surrounds that and the burden and the onus that's put on a tenant to prove these claims after the fact. Already, as it stands, it's very rare for tenants to get even close to the maximum threshold. So increasing that, I don't know, will have a practical effect on the lives of most tenants. And most importantly, at this point, they're already evicted. So what's the resolution here? If they're already gone and out, money might help, right? Compensation might help, but it does not change the fact that they have been removed from their home or community. Reinforcing the stick, which is part of what Bill 184 does, I don't think it changes the incentives that landlords have.
You're talking about the burden being shifted in a way on tenants. How will this change the way LTB hearings are conducted now? Can we talk about how this could change in terms of how and even if tenants can defend themselves in eviction hearings?
So I don't want to be alarmist. There are still mechanisms and procedures that tenants would have to dispute non-payment of rent evictions in particular, which I think is sort of the most significant change of Bill 184. And I think it's actually important for people to understand how that would work. So let's say there is an agreement that is signed between a landlord and a tenant, and they make a plan. So they avoid the initial hearing. Things are going well. Maybe a payment is missed. And the landlord is now able to seek this ex parte eviction order, meaning they just write directly to the board and, pending the approval of the paperwork, they get their eviction. Tenants need to be very, very, very diligent about checking their mail and staying on top of any correspondence from the landlord-tenant board. I can't tell you how often it happens in my practice that someone receives sort of the brown envelope, but they're too anxious to open it, and it kind of sits there. And if these problems are not addressed right at the outset, it becomes a lot harder to fix the situation, because if an ex parte eviction order is granted, tenants actually only have about 10 days to request a motion to set aside. And that motion would then be, bring them to the landlord-tenant board. They might be able to explain the circumstances of the missed payment or whatever other issue led them to not honor that repayment agreement. And then an adjudicator would be able to assess all of the circumstances and decide what's fair, what's not fair. But that doesn't happen unless the tenant takes steps to make it happen.
And I want to talk to you some more about how you think the bill has been packaged and presented in terms of its messaging. It's called Bill 184, Protecting Tenants and Strengthening Community Housing Act 2020. So what do you make of how the Interior government put it out there? This legislation seems to be based on the premise of a sort of symmetrical partnership between tenants and landlords, whereas you're talking about an imbalanced situation here, correct?
Yeah, in my respectful opinion, it's quite a cynical political strategy to sort of name a bill one thing, and sort of the devil is always in the details. And again, I want to reiterate that kind of the history of landlord-tenant law in Ontario and in common law countries more broadly has been about addressing the inequality in that relationship. And that's not to say that tenants are all angelic and landlords are at fault. That's not what we need to take away from this. It's more so if a tenant loses their home, they've lost their home, versus sort of the inherent risk to taking any kind of investment, right? And so if you have a system that is expediting processes for the party that stands to lose not the roof over their head necessarily, but an investment, which is always a risky endeavor, that's problematic. And, just back to the naming and framing of this bill, it's reminiscent of the Tenant Protection Act that was passed by the Harris government in the late 90s, which actually eliminated vacancy decontrol, the issue that I believe is at the root of housing crisis in Ontario. And that was called the Tenant Protection Act, and it removed a very, very important protection. So it's not the first time that we are seeing this. And in fact, I think that it's maybe an effective or strategic form of window dressing because it creates some confusion. And I think people want to give the benefit of the doubt to the government and believe that they're operating in the best interest. But whose best interest is the question that needs to be answered.
Do you think the government was expecting this reaction from advocates and tenants, and even in some cases, landlords? How do you think they reacted to that?
An interesting side effect of COVID-19, and I'm sure that there will be sociologists who write about this in the coming years and decades, is that it really gave people an opportunity to sort of stay home and focus on organizing. The pandemic presented a lot of practical hurdles as far as getting people together physically. There was also room for tenant groups to collaborate and kind of fortify themselves. And we're seeing the results of that in the sense that we are talking about this issue. And it's really top of mind because there's been this movement building from March, and it's not kind of one person or one group. It's what seems to be a loosely organized collective of different collectives. And I don't know that the government was expecting that kind of a strategic response. It's maybe put some pressure on the ministry to try to do damage control and again, put out the talking points that they would like us to receive and accept, but people have had chances to really look at the details of the bill and are rightly concerned, I think.
Caryma, we're in deeply uncertain times as a result of this pandemic, of course. The rental market and housing was already a problem before that. What do you think the Ontario government should actually have been doing to help renters or the situation? And what do you see as the long-term consequences of this legislation on the overall housing crisis?
I'm really glad you asked this question because I believe it's a mistake to sort of look at this as a problem that arose because of COVID in mid-March, and now we have to clear backlog. Backlog has been a problem at the Landlord Tenant Board for quite some time. In fact, prompting the need for the Ombudsman to look into the situation and develop some recommendations on how to improve processes. And let's not forget that the current government has understaffed not just the Landlord Tenant Board, but we'll focus on that for this conversation. There's a shortage of adjudicators, and the sort of inevitable result of that is backlog. So it's either, a crisis that was manufactured because not enough attention was paid, or the more sinister interpretation is that it built up to a point where the status quo was unsustainable for landlords, particularly small-scale landlords who are withstanding burdens that they likely cannot bear. So it's been a mess in the making, let's put it that way. And if we're serious about wanting to address housing issues in Ontario, I think that the notion of no COVID evictions is one that should be taken seriously. And there have to be ways to sort of keep people in place and develop strategies around either compensating landlords in part or making more money available to tenants who could not afford to pay rent, really taking that seriously, because if what happens is sort of a series of mass evictions, where is everybody going to go? And again, for those who have lived in their units for even more than a couple of years, the market rate of rent may preclude them from staying in their community or even in the city.
Caryma, it's always so insightful and helpful to speak to you. Thank you once again for being with us.
Thank you.
That was Caryma Sa'd, a landlord-tenant lawyer and social justice advocate. That's it for today. Thanks so much for listening. This Matters is hosted and produced by me, Saba Eitizaz, Adrian Chung, and Raju Mutter. Produced and mixed by Sean Pattenden, and our director of programming is JP Fozo. Our show theme music is by So-Called, and our episode music is by Mike DeAngelis. We want to hear what stories matter to you. Please send us comments, questions, or ideas to thismatters@thestar.ca. Please consider supporting the journalism the Toronto Star newsroom does at thestar.com. And don't forget to subscribe to This Matters on Apple Podcasts, Spotify, or wherever you listen to your favorite podcasts. Let's talk soon.